I'm CA Prabhuramesha. I have been receiving number of queries as to, in the case of redevelopment, whether there is any protection of MahaRERA to the existing flat owners, or many of the developers claim that bank guarantee they are not able to give because there is a RERA designated account wherein all the money will be invested, and therefore the separate bank guarantee cannot be provided. So the question is whether the existing flat owners get the protection under RERA, or is there any greater loss to the existing societies? Let me tell you a live case which has travelled up to Honorable Supreme Court, that is none other than Goregaon Pearl Co-operative Housing Society. What happened in that case is that Goregaon Pearl Co-operative Society appointed a developer called Sai Estate Developers, who was given a development right, who was supposed to construct 60 flats for the existing members and another 72 flats for the purpose of sale. He sold all 72 flats, entered into agreement, registered agreement, and also entered into PAAA with the existing 60 members. Unfortunately, he could not complete the project in time and rents were not paid. Building was half done. A wing again was half done. B wing was just put a foundation, nothing was done. But at least A wing, majority flats were or the structure was ready. Because more than 10 years lapsed when the builder did not deliver, Goregaon Pearl Community Society terminated the development agreement, and accordingly the Honorable High Court also directed the society to go ahead with the balance completion of the work, and the arbitrator who was appointed, he also gave an order that the third party rights created by the builders will have to go to the builder, and the flats which have been allotted to the third party in building A also will be cancelled, and the entire building can be allotted to the existing members. Having said this, naturally the same High Court also upheld the decision, and this also was upheld by the Supreme Court as far as termination of the developer and allotment of the flats to the existing members is concerned. Now the question arises, what will happen to the flat buyers? There are 72 flat owners who have paid more than 2 lakhs, 3 lakhs to the builder, and the builder is absconding, and there is no way in which the money can be recovered. Therefore, two flat buyers, Sandeep Grover and his friend, approached the National Consumer Dispute Redressal Commission, that is National Commission, for the purpose of refunding the money by the builder, and also made a society as a party. National Commission heard the parties, and then they said that as per section 226 of the Contract Act, they are liable, because once the society is appointed the developer as an agent, the enforcement of the contract can be made by the person who third party against the principal, and the society is the principal, and therefore they are liable to make good the not only the money which has been paid, and also they are supposed to pay 9% interest. Agreed by this order of the National Commission, the society, Goregaon Pearl Cooperative Society, went to Honorable Supreme Court, and they appealed this National Commission order. Supreme Court heard the parties, and ultimately they directed that if the parties can settle the matter, they can settle. Unfortunately, that settlement did not take place, and therefore Honorable Supreme Court dismissed the appeal and upheld the decision of the National Commission, saying that society is liable to pay the money which was paid to the developer, because at that time developer was an agent and the society was a principal. And therefore, even though you may write in your development agreement that it is principal to principal basis, there is no what you call agency contract, that has been held by the Honorable National Commission as a wide open issue, because that particular clause will not hold good. One side you are allowing the developer to construct, on the other side you are saying principal to principal basis. That is not possible. You are giving a power of attorney also on behalf of the society. So therefore society continues to be the principal and the developer continues to be the agent, and thereafter if the agreement is cancelled, terminated, the society steps into the shoes of the principal, and therefore they are supposed to make good their loss. Thus, in the case of a redevelopment, if you do not choose the good developer, then you are going to expose yourself to the liabilities that may be created by the developer. Therefore, be careful when you are selecting the developer. I request you to visit our site again and again, subscribe to the channel, and you will get similar videos. And you please write in the description what type of videos you are liking me to do, so that I will be here to guide you. Thank you very much.